Good evening and welcome to the October 8th, 2014 meeting of the Civil Service Commission. Can we have a roll call, please?
Commissioner Yakubian?
Yes.
Commissioner Yaregi?
Here.
Vice Chair Devine?
Here.
For the record, Commissioner Manukian and Chair Gazarian will be here shortly.
Thank you. What's next?
Minutes.
Okay. We do not have a quorum to approve the minutes, so we'll hold that over to the other two commissioners who are here. Next, please.
Oral communications.
Okay. I see no cards. Is there anyone that wishes to address the commission on items not on the agenda? See?
There's a card right there.
Oh. Okay, we have a card from Mr. Whitaker indicating he'd like to speak last, but it's on item 8, so this would be on items not on the agenda, so we'll disregard this. Okay, thank you. What happened to our chair?
He went back.
Okay. Next item, please.
Recruitment and examination report.
Mr. Doyle?
Mr. Chair, members of the Commission, this is our recruitment and examination status report. Again, it addresses our current staffing, examination load, the dates of exams, and the various processes that we have going. Since our last meeting, it's down a bit. I think we were up at 50 recruitment processes for that meeting. We're down to about 40. I think that's a reflection of we've created a few lists in the last month or so. There's generally a little bit of a bump in recruitment as the new fiscal year begins, but for the most part, again, we're at 40 recruitments for the current time. If you have questions, I'd be happy to try and answer those in this report. This is a note and file item.
Do we have any questions?
No.
Seeing none, we will note and file it. Next item, please.
Eligible list established.
Mr. Doyle.
Mr. Chair, members of the Commission, this is the eligible lists that have been established since our last meeting. As you can see, we have three lists, one promotional and two open. The one promotional, obviously a very small group, 3 applicants, one individual made the list. The others two, electrical engineer 1, HVAC inspector, a little bit of a larger applicant pool, but nevertheless a fairly competitive process in both of these, which resulted in a list of 4 for the engineer 1 and 5 for the HVAC inspector. Again, this is a note and file item, but if you have any questions about these items or these recruitments, I'd be happy to try and answer them.
Okay, thank you. Any questions? Seeing none, we'll move on to the next item.
Request to extend names on layoff list. Underground Distribution Construction Mechanic 1 and Underground Distribution Construction Mechanic 2.
Mr. Doyle?
Mr. Chair, members of the Commission, we've had a few of these over the past few months, but this is ultimately a request for an extension by individuals who were subject to layoff and whose names were placed on a layoff list back in 2012. The grouping that we have today there's actually two separate reports. I guess we'll take them one at a time, but this is for a group of employees, the Underground Distribution Construction Series. We have 1, 2, 3, looks like 9 individuals who are on the layoff list for Underground Distribution Construction Mechanic 1 and 1 individual for Underground Distribution Construction Mechanic 2. Their lists will expire November 15th, 2014. These individuals have requested a 2-year extension, and again, the staff has no objection to this, so it's the Commission's desire to go ahead and approve this. That would be our recommendation.
Okay, any questions? We have a motion.
I move to accept the recommendation to extend the deadline.
Second.
Okay, that'll be unanimous consent. Let the record show that Chair Gazarian is here now, and he will be taking over the meeting. Phone number 7.
Thank you, Mr. Devine. Next item, please.
Request to extend name on layoff list, station electrician supervisor 1.
Thank you. Mr. Doyle?
Mr. Chair, members of the Commission, similar to the previous item, this is a separate layoff list than the others that you just approved. This is one layoff resulting from the position of Station Electrician Supervisor 1, also in GWP. The individual was subject to layoff in October. Ultimately, the list was established in November of 2012, but they are requesting, this individual, Mr. Dwayne Ball, is requesting an extension for 2 years. Once again, staff has no objection or concern with this request.
Any questions?
Move for approval.
Second.
Unanimous consent? Thank you. Next item, please.
Report on interpretation and application of Civil Service Rule 6, Section 2F, pertaining to transfer in lieu of layoff and on appointments of eligible employees from layoff lists.
Thank you. Mr. Doyle?
Are we going to go with the closed session item prior to this?
Oh,
Some
I'm sorry. Am I
discussion.
missing something?
Well, Colleen has to leave, and she has a time problem, so we thought that
Okay.
number 8 may take a while, and we wanted to dispense with the closed session items because she has to be here to vote.
Okay. Why don't we defer item number 8 then, and ask the audience to be excused, save and accept those who are
Either
here
that or
for
they
the
can
closed
stay.
item.
We're going to go downstairs.
Oh, we're going to go
Conference-
elsewhere.
In the conference room to deliberate closed session.
Okay.
Sam's not here yet.
Why don't we deliberate in the back?
It's very hot back
Oh,
there.
it's hot back there. Okay, then we'll have Sam join us over there.
Okay. There are 2 closed session items.
Okay.
Note, so
Is Commissioner Yakubian needed for both closed item discussions, deliberations, or is she able to remain? Ms. Yakubian?
we could.
Welcome back, by the way.
Thank you.
Commissioner Yakubian should be here for closed session item 10B.
Okay, we'll take that first, and then if Commissioner Yakubian is able to remain for 10A closed session, she will. If she's not, she will part for the evening. And we will return for the remaining items on the agenda, which is really item number 8, and staff or commissioner comments on item number 9. Is that acceptable? Yes?
Yes,
Yes.
Very well. Let's be adjourned. We will return.
and we'll report out.
We will return and report out. We will return for a remainder open session, which will be televised or not televised?
Yes.
Which will be televised, and then we will report out as well.
Mr. Chair?
Yes.
Excuse me, if we could read those items into the record, and then we would recess into closed session.
Very well. May I ask Mr. Kwan to read those items into the record?
Closed session, public employees appointment reinstatement request, public employee discipline deliberations.
And those were A and B respectively.
Correct.
Very well. Thank you. Thank you.
Trust me, you want to hear it.
Thank you. We're back, and I would like to resume with item number 2, which was deferred. Mr. Kwan?
Minutes.
Move to approve, dispense from reading. Second.
All those in favor?
I will, yes.
You weren't here last time? Okay. Were you here, Mr. Nukin? Yes. Okay. So it'll be the 3 of us to the exclusion of Mr. Devine. Or should we take a roll call to make it?
Commissioner Devine,
Abstain.
Commissioner Manukian,
Yes.
Commissioner Yaregi,
Yes.
Chair Gazarian.
Yes. Thank you. Next item is item number 8. Mr. Kwan?
Report on interpretation and application of Civil Service Rule 6, Section 2F, pertaining to transfer in lieu of layoff and on appointments of eligible employees from layoff lists.
Thank you. Mr. Doyle?
Mr. Chair, members of the Commission, this is a report really in 2 parts. The first portion will address the interpretation and application of Rule 11, Section 2F of the Civil Service Rules. This is otherwise known as the transfer in lieu of layoff provision. The second part will address what's being called a request for reinstatement, which also requires some interpretation and clarification as to how appointments are made from layoff lists. This matter was brought before the Commission at its August 27th, 2014 Commission meeting by Mike Wiedeker, who is the Assistant Integrated Waste Administrator. Mr. Wiedeker raised questions regarding these two items and further requested that the Commission conduct an investigation into his claims of retaliation. On this subject, while some of the issues raised do touch upon matters that are relative to the Commission's general oversight, our belief is that any investigation involving allegations of retaliation or any type of misconduct, whether that be discrimination or harassment, be handled through the normal channels under the city's investigative unit under the oversight of the city auditor. I'd like to first talk about the transfer in lieu of layoff provision and really our interpretation of that. As the report says, when an employee of the city is subject to layoff, there's one of two things can occur. The first thing that occurs is that the employee would be laid off and separated from employment. The other thing that may occur is that the employee would be laid off from their current position, and if they have bumping rights to a previously held position, they would automatically bump downward to that position, assuming they had greater overall service time than the person with the least seniority in that lower classification. Both of these instances are very, very unfortunate. However, under Rule 11, Section 2F, again, this transfer in lieu of layoff provision, it provides an alternative to an individual subject to layoff from either losing their job altogether or being bumped down to a much lower paid previously held position. Whenever this provision has been used in the past, it's always been with the objective to provide an individual being laid off with a better alternative, or you might say a soft landing into a better position. It's always a very proactive process of finding viable places within the organization to put people in order to avoid an even worse situation. Sometimes another department may have a vacant position that needs to be filled. Sometimes a different funding source enables such a move, and that could be funding available from another department or another fund, such as the federal funds or a grant fund or the utility or even some of the enterprise funds. Either way, it provides, again, a soft landing or a lifeline for someone being laid off from their current position. The Civil Service Rule provision, again, Rule 11, Section 2F, is quite broad. It allows for the transfer to any appropriate position subject to the HR director's determination. It's also purely discretionary on the part of the city manager. He does not have to use this provision, but often does as a means of saving jobs and saving people from being laid off. One example of this would be what occurred in 2012 with the layoff of some employees in the Glendale Water and Power field operation section. And some of those individuals were here tonight. These were employees that were being laid off from the electrical underground work crew. And we had about a dozen of them who were going to be laid off, and they would have lost their jobs completely. The city manager got together with Mr. Steve Zern, and Steve Zern is, at the time, he was the head of both Glendale Water and Power and the Public Works Department, and found alternative jobs for just about every one of the employees that were subject to layoff. Again, these were employees who were going to lose their job completely. And we contacted these employees, and we made offers on other areas of the city of jobs for which they qualified for. Some of those job openings were in the water quality section of Glendale Water and Power. Some of them were in the Public Works Department street section. Some of them were in the Integrated Waste Management section. We even had one individual placed in the traffic painting section of Public Works. Now, not all of those employees accepted those positions, but 6 of the 12 did, and they were very grateful. And they were able to maintain their job, a steady paycheck, their benefits, and just an overall peace of mind. So, for the most part, that process was very helpful and very appreciated by those individuals. I want to address something else in one of Mr. Wiedeker's many memos that he had provided to you. He states that the transfer in lieu provision is only to be employed when the city is able to laterally transfer someone subject to layoff to an equal paying job. This is completely incorrect. One only needs to read the actual provision in the rule to know that it can be more broadly applied. And I will read it again. The city manager may order the permanent or temporary transfer of any employee to any appropriate position as determined by the Director of Human Resources in order to avoid the layoff of employees. He also states that historically and by past practice that this provision has meant a lateral or equivalent position. And again, I'm not sure what he is basing that on. I know Mr. Wiedeker did work for the Human Resources Department many years ago, from approximately 1987 to 1992, and was involved in the oversight of one layoff process. But there have been many layoff processes since then. To my recollection, approximately 6 that I've personally been involved in. And I can tell you that when the transfer in lieu of layoff provision has been employed, we have not defined it so narrowly or interpreted it as narrowly as that to say that someone could only be laterally transferred who's subject to layoff. Such an interpretation would unnecessarily limit many alternative options that we've employed over the years. In the report that's provided here, we have an Exhibit A illustrates the layoffs that have occurred over the last 5 years that have utilized the transfer in lieu of layoff option. And I looked at the last 5 years, not only because they're the most recent, but really when we're looking at large groupings of layoffs that have occurred historically in this organization, we've had a cluster of them occur from 1995 on. Prior to that, there was not a lot of layoff activity. We had one in 1992. There was another smaller one in 1993. But from essentially 1994 to 2008, 2009, there were no mass layoffs within the organization. These were somewhat, I would say, good economic times for the city. But anyway, for looking at the exhibit that's been provided, you can see that in those cases where we've employed this transfer in lieu of layoff provision, there were a total of 22 such transactions. 13 of those resulted in an employee experiencing a reduced classification in pay. 2 of those resulted in a reduced classification with what's known as a Y rate, meaning that the employee was allowed to keep their pay, and that was a unique circumstance, and I'll explain that in a moment. 3 of those resulted in employees being transferred to an exactly equivalent pay grade, and 4 actually resulted in a higher classification pay grade for those individuals. And I want to break these down. By the way, we experienced yet another layoff in the last 2 to 3 weeks, and in this, it was a smaller one, but in that one we were also able to employ the transfer in lieu of layoff provision, taking an individual who was being laid off from an administrator position who would have gone all the way down to a non-management position within the GCEA. We were able to find a middle management position within the Water and Power Department to place this individual in, and he was extremely grateful. So if you look at that in the context of this chart, there are now 23 examples, and again, 14 of them would result in the reduction of classification and pay. But let me point out in this report where I've indicated that 2 of these transfer in lieu of layoffs resulted in a Y rating. This was a unique circumstance, and I'll be quite honest with you. This action occurred in 2009. It wasn't a economic rationale behind it. This was the city's decision to eliminate the park ranger program within the Parks Department, and that was a very key decision in making sure that if we have law enforcement functions that occur in our parks, we would prefer the Glendale Police Department to handle that as opposed to having a very small mini police department within our Parks and Recreation Department. So essentially we laid off all of the part-time, the voluntary park rangers, and there were 2 salaried full-time people who
They
had,
were sworn officers, weren't they? Or-
there were all kinds of
Yeah.
issues. And those 2 individuals, we felt really bad. I mean, they made a career of the park ranger business, but again, we were getting out of the park ranger business, and we eliminated those positions, but utilized the transfer in lieu of layoff process to place them in what were called park naturalist positions. So they were doing much of the same job, education and information in our parks, but they weren't doing the law enforcement. So those individuals were Y-rated. For the most part, though, when we're doing a layoff, we're trying to save money, and to say that when you lay people off and reduce their classification, you have to try and maintain their salaries, it's not going to accomplish any type of cost savings, and it would pretty much eliminate the purpose of doing a layoff to begin with. But anyway, that's what occurred, and that's a reflection of Exhibit A. Again, 13 resulted in reduction in classification and pay, 2 resulted in a reduction in classification with a Y rate, 3 resulted in the exact equivalent pay grade, and 4 resulted in a higher classification and pay grade. And I'll explain those 4. At that time, we had some clerical positions, customer service rep. I think there were 2 customer service reps, 1 senior office services specialist position. These individuals were going to be laid off. They were going to either lose their jobs completely or go bump down to a much lower paying position. Well, again, Mr. Zern, who is often cast as somewhat unfairly as this unfeeling hardline manager, Mr. Zern had some openings for a position called customer service utility rep within the Glendale Water and Power Department. And these are positions that we absolutely had to fill just because of the call load and the volume of customer service needs for that department. So he took these individuals who were being laid off and moved them into Glendale Water and Power. And in some cases, they ended up getting a little bit of a pay bump and going into a higher paying position. So really, again, when we talk about this issue of whether the transfer in lieu of layoff provision must be historically limited to lateral moves, it's completely incorrect. At this point, I'd like to move on then to the other part of this, which talks about reinstatement and reinstatement from a layoff list. This is a lot shorter, so I'll try to get through this quickly. But in his presentation, Mr. Wiedeker made a request to be reinstated to the position of Integrated Waste Administrator. And this is presumably because he formerly held a position called Public Works Administrator. Again, this is an incorrect interpretation of the rules. Essentially, one cannot be reinstated to a position for which they never held. In this staff report, I provide an example of how the reinstatement process works and how the layoff process works. And I give an example of a senior civil engineer. If someone were to be laid off from that position and they were able to bump to their formerly held position of, let's say, civil engineer, they would go to that lower position. And they would be on the layoff list for senior civil engineer. But if there were later an opening for a senior electrical engineer or a senior mechanical engineer, that individual could not be reinstated to that position due to the fact that they never held that position, even though it is a somewhat similar position. In those cases, the individual would have to apply and compete for that position. Bringing this back to Mr. Wiedeker's report, he is in fact the Assistant Integrated Waste Administrator, and yes, we do have a vacant position of Integrated Waste Administrator. However, we are, as you know, in a reduction mode at this time. In fact, we just did another golden handshake, another round of layoffs not too long ago. In the recent golden handshake agreement, we had 73 employees leave the organization once again. And we're in a downsizing mode. We've gone from approximately 2,000 salaried employees to now we're just hovering around 1,500. As far as this integrated waste administrator position, Mr. Galanian, who is the relatively new director of public works, has yet to determine whether this position needs to be filled. Given our downsizing mode, it would not be out of the question for him to decide not to fill that position or to eliminate it altogether. And after all, he has one of his deputy directors within Public Works overseeing that department, and that may very well be sufficient for what it takes to run the integrated waste management section. But that decision will be Mr. Galanian's decision and his alone to make. Seeking commission action to place Mr. Wiedeker into that position through reinstatement would not be proper, nor is it authorized by the rules or the city charter. Again, if Mr. Galanian decides to fill that position, he would have to post a bulletin, and Mr. Wiedeker would be free to apply and compete for it just as anyone else. Those are really the two main areas I covered in the report, and I'm sure you have questions and further comments, and I'd be happy to try and answer those.
Very well, thank you. Did you folks want to entertain questions of Mr. Doyle, or did you, and then we will hear from Mr. Whitaker so that we can keep compartmentalizing the respective positions, or did you want to hear from Mr. Whitaker and then have questions?
I'd like to hear from...
You want to hear from...
Yeah, I'd like to hear from Mr. Whitaker. I thought
Whitaker?
Mr. Doyle's presentation was quite clear.
Okay, all right. Mr. Whitaker?
My name is Mike Wiedeker, and thank you for this opportunity. I'm going to, for the record, provide a handout that I'll refer to. And the good news is I'm only going to attempt to establish three things in the Commission's mind as being true and valid, and just those three things, and I'm only going to focus upon the past practice and historic interpretation of the rule only. So we won't be addressing reinstatement. We will only be addressing Rule 11, Section 2F for simplification tonight. Okay, so I attempted through the city clerk to have some material delivered to you earlier so you'd have a chance to look at it, but if not, I simply want to, again, as I said, establish three things. The first is we need a common concept of what the term "in lieu of" means. The dictionary that I use, and by my belief, in lieu of means instead of or in place of. It does not mean in addition to. And that's a critical thing for us to come to a common understanding on language-wise, because we have heard the phrase used, the laid-off employee is being transferred for their benefit. And it sounds right to our ears, except when we consider in lieu of means instead of, in place of. You may find in an obituary, it might be mine, that it says, in lieu of flowers, the family would suggest a donation to such and such charity. So it's in place of. So with that in mind, if you buy that definition of in lieu of as societally and culturally accepted, in lieu of, transfer in lieu of layoff means either or. We're either going to lay the employee off or we're going to transfer the employee. But it's not both. We're not laying them off and transferring them. It's one or the other. So now that simplifies this to a discussion about our existing city charter and civil service rules. We have rules that define transfers. On the last 2 pages that I've given you of my report, you see it's actually a page and a half of the civil service rules, right out of the rules. I'm now going to hand out a single-page summary, and we'll have to ask Ms. Van Meiden if she would confirm that the text actually comes from the city charter. Sure. The The city charter is kind of like our city's constitution, that foundational document. We can do what the city charter says that we can do. And I've highlighted the section that I want to refer, the city charter. We have a civil service commission because the city charter establishes a civil service commission. Within that, we have a series of rules in the city charter. Rule 9 is labeled transfer, demotion, or reinstatement, and I'm simply going to read that for the record. For transfer, now this is again the rules, Rule 9, for transfer from one position to a similar position or to a lower position upon request of the employee affected. That's really critical to keep in mind that, transfer, the one exception that is not lateral in the charter is at the request of the affected employee. If we look at the bottom portion, the authority of the city manager to, in essence, reassign employees, it concurs, and it says the city manager may assign assistants, deputies, clerks, or employees from an office or department of the city to, in essence, perform work in any other office or department. This is really critical because this is very eye-opening for the commission. There is no charter authority to transfer involuntarily an employee into a lower classification. When you look at the civil service rules, the last 2 pages I gave you, you'll see that they are also have some critical sections highlighted that literally restate and reemphasize what the charter has identified. We have lateral lateral transfers. In fact, the only transfers recognized are lateral transfers. You'll note at the very bottom of the page on the rules that there is in fact a 1% salary increase that's permitted for a transfer into a higher paying position. The rule does not define what a lateral transfer is, but it sets a 1% increase threshold for a transfer to a higher position.
Where is that?
It's on the bottom of the first page of
yes.
transfer rules, the
Thank
very
you.
last line.
Thank you.
So our civil service rules are in essence mimicking the city charter. We have lateral transfers. There is the same exception noted in the rules. It's called either a lower classification transfer or a lower qualification transfer, and you'll see that highlighted as well. And you'll note that such a transfer is requested or initiated by the employee. And if you'll flip the page and look at the back of the civil service rules, there under Section 5, this is a transfer that the employee requests and the commission confirms. So why would you have that safeguard in the rule? This is really critical. And that's because, gentlemen, when it comes to transfers and layoffs, neither of those acts carry due process rights for the employee. Neither of those actions are appealable. And they're not appealable because transfers that are lateral result in no significant loss to the employee. It's a de minimis change. So there is no need for a due process right. So I have great respect for Mr. Doyle. I have great respect for my city. I love my city. I've been with the city 27 years. This is like having a family member whom you love and you just take issue with one behavior they have. And my issue is just with this one interpretation. So I've asked you to agree with me that in lieu of means instead of, not in addition to. I've shown that both the charter and the rules only acknowledge lateral transfers that are not initiated by the employee requesting a downward transfer. And finally, my punchline is, don't take my word for it. What has the historic interpretation and organizational past practice been? And to do that, I took Exhibit A that we were all presented and that Mr. Doyle was gracious enough to send to me, and I wanted to visually depict that data for you to see, because language is one thing. When you're dealing with that much data, it's hard to grasp it all at one time. And in essence, this is the analysis of that data. And so I have given you a series of graphs that were paper clipped. This is graph 1. It's a little larger, so it's easier to see than the one that's in my report. And the important thing here for me to establish in your mind is that this is literally number for number the data that was contained in the city's Exhibit A. The only change is I included the 2 layoffs that were actually not layoffs, but transfers that I was personally involved in. Both of those employees are retired now. We have this gap, and then we pick up where the data left off. Let's look at my key at the bottom. I'm defining all of these layoffs, not layoffs, all of these transfers as lateral transfers. Why is that? There was de minimis change in salary. They were lateral. Okay? This is really important for us to grasp. If you would look at chart 2, I'll come back to this later. Chart 2 is simply the clustering of the lateral transfers and the downward transfers that I'm calling demotions. And I'm drawing your attention to the fact that, just as Mr. Doyle said, there were some de minimis increases that people accidentally got. You know, it was through no fault of theirs and through no fault of the city. Those were lateral transfers. There are even some Y rate transfers in here to maintain employee salaries. The important thing to know is that for the transfers that are lateral, the average impact upon those individuals was a gain of $15 a month. When we look at the transfers that had more significant impact, the ones I'm referring to as demotions, they had a monthly impact of $1,327 per month. Now, I'm a numbers guy. I love people, but, you know, I'm a numbers guy. And so I have to take data like this and take a look at it and ask myself 2 questions. Is this difference between this group and this group, could that be the result of chance? Is this just a freak kind of thing, or is it a meaningful difference? And so I actually ran what's called a t-test, where you take the average of this group, the average of that group, and you literally ask the question, is it statistically significant? If both of these groups of employees were treated the same, if there was no change in the application of the rule, could we get a difference this large by chance? And the answer, gentlemen, is you could. 1 out of every 1,370,000 times. So replicate Glendale by 1.37 million times, and you could, just by chance, get an average of a lateral salary change of positive $15 and an average negative salary change of $13.27. I mean, what does that tell you? That tells you, from a statistical perspective, that it is impossible to say that there has been no change in the application of the rule. 1 out of 1.37 probability of getting a result this big if there has been no change in the interpretation and application of the rule. I want you to look now at chart 4, and I'll be wrapping up in just a matter of seconds. We're going to look at a little bit of history here, in the sense that I'm telling you that the city's past practice has been a certain way, but you shouldn't trust me. We should look at the historical record of the organization. For City Manager 1 and Human Resources Director 1, we don't know what they were thinking. All we can examine is the outcome and result of their behavior. Their behavior told us that transfer in lieu of layoff was interpreted to mean a lateral transfer. We look at a second city manager and our current human resource director, and we see that for that team of 2 individuals, city manager, HR director, that the behavior, the application of the rule was lateral transfers in lieu of layoff. It's not until, and this is a magical date that I'll try to impress upon you, it is not until September the 1st of 2012 that we have on record presented to us as data an example of a transfer in lieu of layoff that resulted in a significant loss. In essence, a demotion. So again, I would sum up and let you know, this is not my data. This is Exhibit A. I'm giving you that ability to look back in time and to literally now look at that same exhibit and say, oh my goodness, there certainly appears to have been both a prior interpretation and a past practice of the organization. Not the current players, not the current people here today, the organization's past practice that a transfer is lateral. So I'm going to summarize my 3 points and then let you know what I'm asking you to do tonight. My first point was in lieu of means instead of, not in addition to, and we agreed upon that. My second point was that the only transfers recognized in the charter and the rules are lateral transfers. There is a caveat for a voluntary request for a downward transfer on the employee's part that they initiate, and that would be permitted in the rules. But that is not an involuntary transfer. All of these transfers were involuntary. The third thing then that I would say is that when we take a snapshot at the history of the organization, we actually are overwhelmed with the fact that prior to September the 1st, 2012, there is not a single instance in which we're presented that a transfer was a demotion, that a transfer resulted in a significant loss. If it would have resulted in significant loss, the organization has given us the answer. We Y-rated those employees' salaries to prevent that loss and, in effect, comply with our transfer rules. So, with that summary, what I am asking this body to do is to not render a new interpretation. I'm not asking you to do that at all. I'm simply asking this body to affirm that the previous historic interpretation and past practice demonstrates that the organization's interpretation of this rule was transfers are lateral, and a transfer in lieu of layoff is not in addition, it's instead of. Those transfers must comply with the charter and the rules, and they are lateral as well. So I really am appreciative of this opportunity to present to you. I hope that it was eye-opening, as it has been to me, and you've, Mr. Doyle has been just as gracious to me as you have been in affording me this opportunity. So I'm going to step aside now. Thank you.
Thank you. Mr. Kwan, you want to remove that item in the easel to the side? Okay. I'm going to open it up for questions, and I will ask Mr. Doyle at the outset, before I yield to my fellow commissioners, if you have anything that you feel that you need to urgently elaborate upon in light of Mr. Whitaker's presentation, or you would like to reserve an opportunity to opine or respond perhaps as we proceed, so that I can defer to my commissioners.
Mr. Chair, I can respond now, but I would like to also reserve the right to respond if more information is necessary. Mr. Whitaker appeared on August 27th with his presentation. He had a handout then. The following week, he appeared in my office with yet another more extensive handout, of which both of those items were included in your packet today. I'm told that the following week he had emailed something to members of the commission. I was not given the courtesy of getting a copy of that, and I understand this presentation was emailed to the commission earlier this week, and again, I was not CC'd on that email as well. I would have appreciated that courtesy. As your staff member, you've received a lot of information from Mr. Whitaker, and again, I would appreciate your indulgence in having the ability to respond as needed.
I certainly can appreciate that, and if at any time you are of the opinion that you need additional time to review so that you may appropriately respond to that which has been handed to us and to you, I am more than happy to re-agendize this item and continue the matter. Despite the fact that this has been going on for some time, I don't want any party to think that they are not going to have their full opportunity to be fully heard by this commission.
Mr. Chair, I don't think that would be necessary, but I do want to state, I mean, in response to the presentation, the graphs Mr. Whitaker provided do accurately depict the exhibit. I think it's his editorial comments and interpretations that I think are not accurate. But the one thing that I think is key, he drew a line on September 1st, 2012, and said that this was the first time that non-lateral transfers in lieu of layoff were utilized was September 1st of 2012, and that's just not true. There was a couple incidents prior to that. There was the 2009 incidents. So that flat-out comment was not accurate. But I think the presentation by Mr. Whitaker completely misses the point of what we're trying to accomplish with this provision.
You may be correct, and that is something that I want to ask to Mr. Whitaker. So rather than have you, for lack of a better word, defend the city's actions thus far, perhaps I will now yield to my commissioners to shed more light with questions or opinion or commentary. I will then add on to theirs, and then I will return to both of you. I think you have asked us to be heard, so I will yield to Commissioner Devine.
Okay, well, thank you. I do have quite a few questions, and I've broken them down in three categories. First, and it comes back to what Mr. Doyle just talked about, I'm calling it the process. Not receiving and receiving certain documents. So the first question questions concern the process. The second one, I want to discuss the staff report, and finally the interpretation of the rule that we're talking about tonight. Back when this started, I think it was August 27th, after Mr. Whitaker addressed the commission, I believe, and correct me if I'm wrong, asked staff to do several things. One was to take his report and write a response so that we could understand the city's position on it. Part of that request was that before it came back to the commission, we asked that you share that response with Mr. Whitaker so that when the thing finally came back to the commission, we would have both sides and we wouldn't have to carry on and go back and forth. That didn't happen. And
sorry for interrupting, but that was not my understanding of the direction from that commission.
I think if you play the tape, you'll see that I specifically asked for that to happen.
Mr. Devine.
Well, let me finish, and then I'll let you.
I fully intended to provide the staff report to Mr. Whitaker, which I did the Friday morning that it appeared on the agenda. He had 6 days to prepare whatever type of response he had for it. But he appeared in my office that week and asked for that he be allowed to read my report and rebut it, and then we could have the commission decide what would end up on the agenda. And I told him that I don't know how we functionally do this to where we're not violating the Brown Act, where I'm given turning in a report, and he's turning in a report, and then the commission therefore has to decide what gets on the agenda. Maybe I misunderstood what the direction was, but this request seemed a bit unusual and certainly not what I'm used to as your chief examiner. When I'm given an assignment, I prepare a report, and it's delivered to the commissioners, it's placed on the agenda, and that's generally how we do business.
I'm going to ask you to continue, Mr. Devine, but I want to make an inquiry. The report that is in my agenda packet and all of our commissioners' agenda packets, which contains your report as to this item, when did Mr. Whitaker have a copy of that?
It would have been the morning we released it for the agenda, which would have been the Friday before the following Wednesday's meeting, which would have provided him with six days, Friday,
Okay.
Saturday, Sunday, Monday, Tuesday, and Wednesday, if he wanted to come and prepare a rebuttal for that.
Okay.
As it turned out, we didn't end up
That's
having
fine.
it that Wednesday
That's
due
fine.
to Mr.
I have
Devine's
my
absence.
answer. Mr. Devine, proceed.
Okay. Well, anyway, when I did the rundown on the dates and times, there apparently was some confusion on what was supposed to happen, and I understand that Mr. Whitaker did not have the opportunity to have a copy of the report when it was prepared so he could prepare a response. Thus, the other letters came in. You know, he felt that since he didn't have the city's response, he, I guess, issued that or did another analysis of it, and that was the one he submitted to the city clerk. Anyway, the process was very convoluted, and
I agree.
Didn't follow my understanding and what I specifically said during that hearing in terms of how I thought it should work. So that leads me up to my first question. I said, why wasn't the process requested by the commission at that meeting followed? And if the answer is that it was not legal to do it, why wasn't the commission informed at that time? So that's my first question regarding the process.
As I said, that was not my understanding of what the commission wanted me to do. Again, I was given a direction to...
But I'm sorry, I'm going to interrupt you. I think it was followed, though. If you're saying, Mr. Doyle, that you made available your report on Friday morning when the agenda was published.
It was emailed to
Or
Mr.
emailed.
Whitaker.
Very well. So I'm not following as to what was it that the HR did not do
The HR report was prepared before that,
before Friday.
before that time, yes.
So, but it was given on Friday preceding the following Wednesday that this item was supposed to be initially heard, correct? Right?
Yes.
That's what
Right. Is that correct? Did you, forgive me, I'm sorry because I need to run this somehow. Mr. Whitaker, did you get an email copy of the report of Mr. Doyle to our commission?
I absolutely did on that Friday morning, sir.
Which would be prior to the Saturday and Sunday and Monday and Tuesday preceding the Wednesday meeting to follow?
Correct.
All right. Thank you.
Okay.
So I think we should move forward from
Okay.
that issue,
All right.
Mr. Devine.
The next question deals with the staff report. And it appears, again, your justification for saying that the transfers in lieu of layoff were justified and allowing them to go to a lower classification. And in my reading of your report, it seemed to be all based on the historical and past practices of the city in terms of doing that.
Mr. Devine, the historical and past practice were not I was not the first one to use those terms. If you look at Mr. Whitaker's initial memo that he handed out here on August 27th, he's the one who alleged what the historical past practice was. I was merely trying to point out, and with Exhibit A, that really his interpretation of what's been the past practice is incorrect.
So in your report, you say the purpose of this report is to detail the city's longstanding interpretation and application of the provisions of that particular civil service rule. And then you indicate that, this is on page 2 of your report, the vast majority of these actions have historically resulted in the placement of employees in classifications pay that is lower than existing positions. And then you say there is simply no historical or past practice evidence that the transfer in lieu of layoff provision were established to provide for the exclusively lateral or equivalent position.
Correct.
So, however, in the data that we received tonight in terms of these graphs and charts, it appears that there was not a historical past practice that would justify your position. So that, again, is my question. How does the staff report support their past practice justification for the city manager being able to transfer the lower class to a lower classification in lieu of layoff when the data does not appear to support this contention?
Commissioner Devine, I'm not sure what data you're looking at, but Exhibit A shows, at least since 2009, that the majority of these cases did result in a lower classification and lower pay.
Okay.
And
Well,
that's the past practice I'm referring to. And again, I started this looking at 2009 because, as I said earlier, we didn't have a lot of layoffs occurring between the 1992-93 time period and 2009. The Great Recession hit in 2008, and I think that's sort of indicative of why you see a change in the number of layoffs, and on top of that, the number of times we've invoked the transfer in lieu of layoff procedure, and the amount of savings that we're trying to achieve in dealing with what amounted to multi-million-dollar deficits almost every fiscal year, starting from 2009 to 2013.
okay, well, again,
That's the reality.
I understand that, but again, when we talk about historical and past practice and whatnot, and the charts that Mr. Whitaker presented tonight, at least my first glance at them appears to be that this practice started, of the lower classification transfers in lieu of layoff started in 2012, 9/1/2012, as opposed to looking at the history of what I would call past practice. So I guess what you're telling me is that in the city's opinion, past practice includes only from 9/1/2012 to 2014, when the majority of the major layoffs or transfers in lieu of layoff occurred with a major reduction in pay. So the bottom line is this area here from 9/1/2012 to 2014, are you saying that in the city's mind this represents a history of past practice?
It certainly does. 2009 is a...
No, it's 2012, 2 years.
Mr. Devine, look, the majority of the layoffs that have occurred in the recent past have in fact occurred starting around 2012. That was the year we had a $15 million deficit gap to close. So if you're saying the past practice is only established based on this number of year, I'm going to say back to you that we had a large number of layoffs occurring in that era, and so at that point you do see the history of our layoffs occurring, and again, there were many of these transfer in lieu of layoff situations that occurred then, and there were some prior to that. But we're ignoring a prime example of at least 3 of them that had occurred in 2009, and another that occurred prior to September. Actually, there were one. There was an additional one that occurred in 2012 prior to 9/1, but nevertheless.
Mr. Devine, if I may, I think it's really important for this discussion that we're on the same page as to how we're defining and using these terms.
Yes.
Because I think you're looking at the same terms. One of you is calling them a transfer,
Right.
The other one's calling it a non-transfer. So you're seeing the same action that occurred in history differently. Mr. Whitaker has defined all these layoffs or these actions that occurred prior to September 2012 as transfers, and anything that happened after that is non-transfers. So it's really important that we're on the same page using that, and that is a critical, the crux of this discussion. It's critical that we define those terms. And one of the issues raised by Mr. Whitaker, which is central, is this definition of transfer, and where it is in the in the charter and in the rules. So I myself, for purposes of this discussion, really need to go back and take this under submission and review the rules and the charter myself to see what those definitions are. Personally, in my opinion, the policy that the city has instituted is a good policy and has saved several people from being laid off. There's a separate question as to whether the rules themselves now justify those actions, or somewhere in the charter we can stand by what has occurred. So,
Yeah.
And I agree with him. That brings me to my third point, because I did just what you suggested needed to be done in terms of what is the definition. So Mr. Whitaker went over the charter provisions where my first question is, and I'll ask this to Ms. Van Meiden, does the commission have the authority to interpret civil service rules?
Yes, the authority of the commission as defined in the charter is in Section 2, and that's Article 24 under civil service. And those rules provide for the following: the classification of positions, competitive examinations, advertisement for same, eligibility lists, grounds for rejection of candidates, and it's enumerated therein. It also talks about transfer, demotion, and reinstatement, but further within the charter provision, and that's in Section 2, it talks about further provisions as to adoption of rules. So the Commission has the authority to adopt rules that are inconsistent with the charter, and that may be necessary to carry out the provisions of this article. Now, the article also discusses separations of employment. And in that latter part, it's abolishment of positions and procedures to removal, suspension, and reduction in rank. And those come in Section 9 and 9B. And that there shall be rules which that authority is provided, so the rules can address those things. And so what you see within the rules are the reinstatement provisions, as well as the transfer in lieu of layoff and the layoff provisions. And that's where there appears to be a distinction in the rules between the transfer section, which is Rule 9, and the layoff section, which is Rule 11, and that particular rule that we've been discussing, which is at 2F, which is distinct from those that are laid out in the transfer section that was handed out to you.
I want to say, Mr. Devine, that you're specific to your question of does the Civil Service Commission have the authority to interpret the Civil Service Commission rules? My position is absolutely yes, because we do that as an essential function of the Commission. We enforce the rules by interpreting the rules and thus applying the rules. Of course, we have the authority, as our counsel indicates in greater detail, but for me, the short answer is yes.
Okay.
Yeah.
So with that answer, then, I did what was suggested a minute ago. I went through the rules and the charter, and I first want to know what transfer meant. Good question. And this is in the Civil Service Rules, page 6. It says, transfer shall mean the process of moving a position in the same class laterally, intra or interdepartmentally, or divisionally, or between classes possessing similar qualifications, or moving from one class to a lower classification, then all as set forth by these civil service rules. And when I read this, the key word for me was all, because this told me, at least in a non-legal interpretation, that all of these provisions are set forth in the civil service rules as to whether or not they're lateral or whether or not they're moving from one class to a lower classification. So then I proceeded to go through the rules, looking at each of the transfer and transfer authority provisions, and as Ms. Van Meiden mentioned, Rule 9 contains transfer provisions to talking about to lower classifications, and Rule 11 contains it. So when I read the specific rules for those transfers, we'll start with, this is in Rule 9, Section 2C, talks about similar qualification transfer and lower qualification transfer may be granted upon written request of employees. So in this handling of lower classification transfer, it is set forth in the rules that for this particular situation where it's requested by the employee, it can be to a lower classification. So it is set forth there. Then I went to Section 3, where it says transfer authority of city manager. Nothing contained in these rules shall be construed as limiting or restricting the authority of the city manager to temporarily transfer and assign. Well, it talks about his ability to transfer and assign employees, but there is nothing mentioned about lower qualification transfers. So this would not fall under my definition of all, because it does not specify that it can be a lower qualification transfer. It's not set forth in this particular section. When we look at the layoff section, Section 11, they talk about seniority and layoff. They have equal or lower formally held classifications. In that section, Section 2C of Rule 11, it does set forth the fact that these transfers can be to a lower classification. So that gives the city manager and department the ability to do that in that case. We look at paragraph D, or paragraph D in that same one, assignment to classification not formally held. In that case, it does set forth the fact that a transfer can be made to a vacant lower classification. So then we look at the one that we're talking about tonight, paragraph F, Section 2. Transfer in lieu of layoff, the city manager may order the permanent or temporary transfer of any employee to any appropriate position as determined by the Director of Human Resources in order to avoid the layoff of employees. In this paragraph, there is no mention of lower classification. It does not follow the definition as far as the lower classification is going to be set forth in all of the paragraphs where it applies. It is not set forth in paragraph F. So my interpretation would be that in this particular case, the city manager does not have the authority to go into or transfer to a lower classification, the pay reduction. So again, that's a non-attorney's view of it. I agree with what you mentioned, that you need to look at the definitions and how it applies. But my cursor and actually detailed look at it would conclude that based on that simple definition that I read initially, the Section 2F, Section 11.2F does not give the city manager the authority, or cannot be interpreted to give him the authority to transfer to a lower classification. Now, I agree with you 100% that it's a great idea, it's a great provision. I think, as Mr. Doyle very adequately pointed out, it saves jobs. It's a good thing for the employees. My only concern is that it is not, at least in my reading, in the rules, and at the very least, we should be looking at a rule change where we would plug that one provision into that one paragraph, which would include the ability to transfer to a lower qualification.
I share Mr. Devine's concerns, but unfortunately, I haven't studied as closely as he has.
That's right, but I'm just saying that's my position at this point.
Okay.
And I'm done.
All right. Do you want to say anything? I want you to reread Section 2F out loud, and I will stop you at the operative word, and we'll have a short conversation about it.
Transfer in lieu of layoff.
Yeah.
The city manager may order the permanent or temporary transfer of any employees to any appropriate position.
Any appropriate position. What is your interpretation of that word, appropriate?
To me, it's appropriate, and it's also defined, because I had that same question.
Okay.
What is appropriate? Very good question. To me, and what I read was that appropriate means, and that's where it falls into the purview of the Human Resource Director.
It's what I say it is. No, I'm kidding.
No. Okay.
It falls into his purview that appropriate means in terms of job specs, job classification, the ability to do the job.
Okay. I guess this is a good time for me to talk about what I think the issue is.
If I may,
Yes.
because I think I agree with Commissioner Devine with what he just said. It has to do with.
You cannot predict this commission
And I'm not a lawyer.
or anyone sitting
I'm not
here.
a lawyer, and I'm not an engineer. So,
Yeah, go ahead.
you talk about the appropriate position as determined by the Director of Human Resources. I think, and again, my interpretation would be that this was entrusted to me, or this person sitting in this chair, because I would have a level of expertise, knowledge, access to such things as a job description, such things as organizational knowledge, what's going to work, what's not going to work. Would someone with a background in engineering be suitable to place them in a law enforcement background versus something along those lines? And I think that's how we've interpreted this, and that's why it does say the HR director would make that determination. Again, it's not the city manager, it's not anyone else. It is embodied in this position because again, I'm in charge of the classification plan, I'm in charge of the hiring process, I'm in charge of all kinds of things that would enable me to make that determination of what I think is going to work and whether an employee is in fact, number one, if they can be saved from being laid off, but number two, if we can place a person in a position where we feel they're going to succeed and be a continued productive member of this organization, I think that's where this provision came from, and that's sort of the beauty of that provision.
I agree. Let me just ask one question.
Please.
In that analysis, Mr. Doyle, do you take into consideration whether the position is an increase in pay, same pay, or lower pay?
Absolutely. All of those factors are considered, and I think I agree with everyone here, including Mr. Wiedeker. Ideally, you want to find a position that's comparable in pay, but I think the two factors that are most important here is one. Is there an opening somewhere else? Can we find something in this department or that department? And two, if we were to place that individual into that position, would they succeed? And in some cases, I would have to make that determination. No, but in some cases, and again with Mr. Wiedeker's placement in integrated waste 2 years ago, we truly felt that he would succeed in that particular position. So that decision was made when following his layoff from that other position. So.
Okay. When Mr. Whitaker was transferred in lieu of a layoff, instead of being laid off, he was transferred to a position that was less paying, correct?
That is correct.
And he was transferred to a position that was less paying because, in your judgment at the time, there was no equal or almost equal paying position available elsewhere that was suitable for transferring instead of laying off Mr. Whitaker. Is that correct?
That is correct. I mean,
at the time.
Again, in collaboration with the city manager, the public works director.
Well, I assume so. I assume so. Because my dilemma is this. As Mr. Whitaker has pointed out, if transfers are all meant to be lateral transfers, because if they are lower pay transfers, they are, for almost all instances, I'm sure exceptions are noteworthy, they are deemed, or we can say that generally they are involuntary. After all, who in their right mind would want to be transferred to a less paying position? Now, of course, I can make a case that less paying position with less responsibility, less stress, well, maybe, but
and
generally...
There are provisions for that in the rules.
But generally, if people are being transferred for a less paying position, are those individuals, and now having a general discussion with respect to the rule that this agenda item is about. This agenda item is not specifically per se about Mr. Whitaker. This is a rule interpretation agendized item. When people are being transferred to a lower paying position, is it fair to say that they are only being transferred under one of two circumstances? One, instead of being laid off, or two, in a setting where the employee that is being transferred to a lower paying position is consenting to that transfer. Is that a fair statement?
I think it's a fair statement, and it is fair to say that the employee could, I suppose,
say no.
They could say no and say,
right.
You know, I'd rather have unemployment, or I'd rather stay
That's
home.
what I want to get to.
Or I suppose they could say, you know, I would rather work in this much lower paying position. But
because
since I've been around, we've never had somebody do that. We talked about some of those electrical worker employees who decided to turn us down with those positions, and that was
and they were laid off.
They were laid off. They lost their jobs.
Okay, so if I want to balance that with existing rules and safety measures in place within the civil service rules, wherein protection is provided to an employee who is transferred to a lower paying position, which at times may be disciplinary in nature, being transferred, demoted to a lower paying position, that employee, we all would agree, would have his or her civil service rights kick in when that demotion, lower paying transfer of a movement has been instituted within the department.
If it's for cause, yeah, absolutely.
That's
They're entitled to due process
right.
rights.
So absent any evidence that a transfer, despite its resulting in lower pay, absent any evidence that it is disciplinary in nature, but yet couched as something else, if it is in lieu of a layoff, instead of a layoff, the employee can say, thank you for the offer for me to make less money. I am going to now decline that offer and make no money from the city and just go on the unemployment ranks, right?
They would have that ability.
Okay.
Yes.
Now, your report to us, the first page, you referenced the exhibits B and C that were submitted by Mr. Whitaker, in which he requested additional actions by the Commission, including requesting that we conduct investigations relating to retaliation and a purported layoff list. Of course, those issues were not addressed in your report, and the reasons were cited to be either for confidentiality reasons or outside the scope of the Commission's duties. You did indicate that the complaint by Mr. Whitaker regarding alleged retaliation will be investigated fully by the city's investigator from the Internal Audit Division. My question to you is, can we be provided with a report by the city investigator from the Internal Audit Division? Can we? Are we privy to that? And if so, when do you think that would take place as to that issue? That's something that, if you need to research and give me a report back next time, do so. I'm just curious, so I can.
That would be unprecedented.
Okay.
And maybe Mr. Van Meiden can weigh in on that, but.
The reason I ask, Mr. Doyle and esteemed counsel, is because as our chief examiner, you are saying it is outside the scope of this commission's duty. And I have not, as my fellow commissioner, really researched each and every position that you have taken in this report, so I don't know if it is outside the purview of this commission to engage in any investigation relating to retaliation. Of course, I do know that there is no matter before me that is brought before me other than this open session agendized item for a rule interpretation. So I want to stay focused, on the agenda item, and I don't want to really deviate, but it begs the question because it has not been addressed. It was posed, so that's why I posed the question.
Sure, Mr. Chair, members of the commission. Typically, the investigative, if there's an allegation of a problem such as was alleged in the letter, that would be undertaken by the human resources manager as described. There isn't, what the commission's powers are is to look at the efficiency of the service of the commission, and so that's within the purview of the commission. And then to investigate anything beyond that we would refer back to the charter. Okay, and the charter tells us that those investigations are to be undertaken internally by the human resources director.
Okay.
And it also begs a question of, in the event that there is if the commission were to undertake an independent investigation from the process that we already have, and then ultimately sit in the position within a disciplinary proceeding, it creates an internal conflict of interest, and that's one of the reasons why that particular investigative power is reserved for the human resources director.
I'm very comfortable with the process as it is in place. I would add that at such time, if at all, there is an undue delay in a finding or a report being generated by the city's investigator from the Internal Audit Division under the direction of the Department of Human Resources, I suppose that is the time to seek intervention from the Civil Service Commission to see to it that
The efficiency of
the
service is maintained, and that is within your purview. Yes.
Very well. Okay, thank you. Now, with respect to Mr. Whitaker, as it relates to the rule, being given the opportunity to elect between being laid off or suffer a reduction as a result of a transfer in lieu of a layoff instead of a layoff, did Mr. Whitaker get consulted when that transfer happened, or he was just told that this transfer happened and he could accept it or reject it, if you recall?
I really don't recall. I wasn't in the room.
What is the general rule? What is the general practice?
General practice is that an employee subject to layoff is given notice of that, and if they have bumping rights, they're noticed of the bumping rights, and they're told the position that they would bump down to. And if there are no bumping rights, they would be told, your date that you will be separated from employment.
I see.
When again we're able to employ this particular provision and identify a better alternative, for lack of a better term, they are noticed of that. I don't know if Mr. Whitaker was told you can take this or you can choose to take a much lower position, which would have been the case. I wasn't in the room at the time, but that right certainly does exist. Any employee can turn down this offer.
Okay, and it is your position, if I'm misquoting you, please correct me. It is your position that with respect to the analysis of the city's Exhibit A, which Mr. Whitaker brought the big chart and did his presentation with, it is your position that when you look at it historically, you're stating that up until 2008, I think you said, or 2009, from 1994 to 2009, because in my mind it stuck a period of 15 years. I believe you stated we were in relatively healthy economic condition in the city. and then things changed in 2012. And I do note that the chart does reflect an ever-increasing transfers instead of layoffs to a lower-paying positions as opposed to more lateral. But what I do want...
Sir, that does correspond with an ever-increasing number of layoffs in general.
Right.
There were two huge waves of layoffs that occurred in 2012, one around the summertime, August, September, and then there was a second one in October, November. The biggest round of layoffs that the city's experienced since the Proposition 13, and I wasn't around for that.
Mm-hmm.
But that's essentially what we're seeing. I mean, this is a reflection of the economy, the budget, the recession, and our need to balance our budget.
But it's really a low number. But from your report, you're referring to 22 times in the last 5 years,
yes,
and you're giving the results. When I look at the results, and I'm a numbers guy, Mr. Whitaker, I'm a real numbers guy. I don't think I like anything more than numbers. And I did an analysis, and it looks to me like in 40.9% of the time, there was no loss in pay, and 59.1% of the time, I think, there was loss in pay. And if I want to simplify it further, 4 out of 10 people did not suffer any loss in income. But a greater number of people did suffer. 6 out of 10 did. And I'm not taking into account somebody getting a slighter, higher classification ranging from $11 to $260 per month in higher pay, which translates to roughly $3,120 at the high end of a annual rate increase. In this being a transfer in lieu of a layoff, that's a hell of a transfer in lieu of a layoff when somebody gets another $3,100 in raise in pay annually. But 6 out of 10 people did suffer a loss in pay. Now, are there, with respect to the heartache of Mr. Whitaker, are they or are they not these two positions that Mr. Whitaker keeps referring to, what he held once, what is now available again, that he ought to go there? Are they different positions, or are they the same positions with different name labels attached to them? I don't know. I'm just asking the question. Because one is Public Works Administrator, the other one is Integrated Waste, and I don't know what Public Works is compared to Integrated Waste. Are they different positions?
Yes, Mr.
They
Chair.
are.
They're two entirely different job classifications.
Okay. All right. And
Just to note, the Integrated Waste Administrator does actually pay more than the Public Works Administrator.
okay. It pays more.
Correct.
Okay. And I'm to understand that part of what Mr. Whitaker is asking for is seeking reinstatement to a position of Integrated Waste Administrator, correct? Which
yes.
you think, which you believe it's not proper to be asked of this body. Is that correct? Okay. Now, let me make sure here. Okay. Now, the 59% that I talked about, out of these 22 people that got losses in pay because they were transferred in lieu of layoffs, instead of being sent away with no more salaries coming their way, they were transferred to positions that they essentially kept the job but made less money, correct?
Let me just correct it. There were 22 times that was employed.
Oh.
And it was 13 of those resulted in the reduction in classification and pay. 2 resulted in reduction in classification with a Y rate. 3 were exactly equivalent.
Yes.
Okay.
13 of them, yes. But that's what I'm saying. Out of the 22, 59%.
Correct.
Yeah, the 13 is the 59%, right? As to those transfers, if I'm to read into Mr. Whitaker's mind, and I may be wrong, if I'm to look at those as demotions, which are not appealable, I think that's a phrase that Mr. Whitaker used at some point. These are transfers, but essentially perhaps demotions in pay, if nothing else, or title, or both, that are not appealable due to layoff provisions. How do we reconcile that with an employee's civil service rights to appeal a demotion which is not layoff-driven, but a demotion that is performance-driven? So in other words, if I'm to say, wait a minute, every time someone is being demoted for performance base or some bases that a supervisor deems worthy enough to demote this employee, that employee has the right to go seek review, appear before civil service, and get their day before this commission. By contrast, here we have 22 instances where 13 of them did not get that right because they were being transferred in lieu of a layoff. It's not because they were not good at their job. It's just that their job position was being eliminated because of economics. And you know, those of you who know me know that I am going to look out for the underdog, and the underdog is always the employee in my mind. But I cannot seem to find so far something that I really can hold on to, that the underdog is being beaten up, because if economic causes are what's driving this move, I'm satisfied with the 22 examples you've given, Mr. Doyle, because the 22 examples essentially show me that, as I said, 41% of the time there is no loss in pay. I would have been happier if 100% of the time there is no loss in pay, but I'm satisfied that it is not. If it was 100% of the time loss in pay, loss in pay, loss in pay, I would say, wait a minute, maybe something going on here. Maybe you folks are not being candid with this commission. I haven't seen that, so there may be something there that I haven't seen, Mr. Whitaker, but I have not seen that which before me, because what I'm concerned about is I don't want to be evaluating rumors. I don't want to be evaluating rumors as a commission. I don't want to be engaging in speculative conclusions either. There are things in your report, Mr. Whitaker, that you have made references. It has been rumored, is one thing you have said. If true, retaliation for having participated in the prior administrator's investigation would be the only logical explanation for my having been placed on such a list. Those things, they do not pass the evidentiary test that I operate under. I am, my colleague here is a lawyer at least, and the engineer, though, is not a lawyer. I have to adhere to some evidentiary standards. Thus far, I do have rumors and speculation, and sometimes when there's smoke, there's fire, but other times when there's smoke, there's really only smoke and no fire. The requests that you have made of this Civil Service Commission are troublesome to me, because I believe that at the time that you were transferred, and I say this to my chief examiner as well, the time to have, if there were bases in the rumors or the retaliatory action being taken, I think the appropriate action would have been to reject that transfer, or to take a position and deem it to be retaliatory transfer or transfer based on performance, and seek review by this commission. However, that transfer seem to have occurred 2 years ago, and if you tell me, okay, Chair Gazarian, I'm seeking it now, my unfortunate response to you would be, it's untimely. You know, it's untimely and way past the deadline. So I don't know that I can grant you your day before this commission to further elaborate those issues that you refer to as rumors or retaliatory in nature, simply because of the passage of time and the time constraints and the requirements that I have to abide by. And I see you at the podium, and I'm happy to hear from you.
And I could not agree with the chairman more. My claim of a retaliation act was not in relation to the first layoff, the first transfer in lieu of layoff 2 years ago, but to a subsequent this year layoff that was pending. And so I don't want you to think that I'm coming 2 years after the fact. I'm coming to this body. And I would agree that there is absolutely no place for rumor in the organization, especially such harmful, hurtful rumors that really impact an individual. In fact, we have people here in the organization that are charged with ensuring that we do not have a hostile workplace where people are not permitted to say such erroneous, hurtful, harmful things, because it's just damaging. And I have approached to executives of the organization and broached this subject with them. This rumor is rumor, it's harmful, it's hurtful to me, and let's clear this up right now. Look me in the eye and tell me that it is not true, and then we can move forward from that. And both executives had to decline. Now, to their credit, they honestly declined to tell me with full knowledge of whether my name was or was not on the current layoff list. They declined to correct this malicious, hurtful, harmful rumor, and it would have been so simple. In fact, I would argue they have the moral and ethical obligation as executives with knowledge to clarify that for me, that it was not true.
Have you been given notice of a layoff to you?
Actually, I have not. As long as I'm here, I would want to raise one other issue regarding layoffs, because your comments about 2 years ago are very appropriate. You're either laid off or you're transferred, and we're painting a picture that a transferred employee should be appreciative of their employment, and that is absolutely true, and it's true of me as well. But here's the Pandora's box that we open. Once we say that an involuntary transfer can take place under our rules, you have just created a caveat in which, through no financial necessity, and our most recent round of layoffs, Mr. Doyle will attest to this, the city manager's letter says it's regrettable it's taking place. It is not happening for financial reasons. It's due to restructuring and efficiencies. Now realize the corner that you've turned. It's not financially driven. We're simply reorganizing Department A. We're going to, regrettably, I've never cared for Mr. Doyle. I hired him and trained him. However many years ago, I actually did hire him. He's a wonderful employee. I trained him beautifully. But you know what? I have a problem with him. I'm in authority. If I fire him, if I demote him, it won't stand up to muster. He's a smart man. He will appeal, and my veiled action will be revealed as inappropriately harsh. But once you give me the authority to say, I'm just reorganizing, I no longer need this position, I'm going to transfer, in fact, I'm going to demote or remove Mr. Doyle, and under both conditions, he'll have no appeal rights, no due process. You've literally created the situation in which no employee ever need be disciplined again. Why grant due process rights? I really want to get rid of them. I'm going to lay off. I'm going to transfer in lieu of layoff. I'm going to successfully achieve the punishment that I want to give, and there's no appeal to you. That is a slippery slope that I would invite the commission to think long and hard. Why would the charter say lateral, similar position, unless initiated by the employee? Now, civil service rules say the same thing. You'll look me in the eye and you'll say, but Mr. Wiedeker, you didn't have to take that transfer. Okay. We go right back to the false discipline scenario, and you're now going to say, you are either going to accept this or you're fired, Mr. Wiedeker. There's no appeal. Again, you've just granted the organization the authority to never discipline me ever again. Just reorganize, lay me off, and now you can demote me or remove me, and I have no civil service right to come before you and say this action should be reviewed by another entity. My property interest right in my job has just been forfeited. So that's a very serious conversation that we're having. All I'm saying is not Mr. Wiedeker's right. Again, the charter and the rules say transfers are lateral unless initiated by the employee. Blackmailing the employee into accepting non-appealable discipline is not a transfer. We can say that 40.1% of the transfers had no negative effect, but 50-something did, and that is essentially, I'm going to disagree with you, despite your acumen for math. When you look at the lateral transfers, de minimis changes, a lateral transfer can have a slight increase or a slight decrease. Again, we're talking about transfers in the thousands of dollars. I'm going to give you one more Pandora's box you've opened. Once you say that I can be transferred into a position paying thousands of dollars less, I can be transferred to a position paying thousands of dollars more. You've just circumvented the reason civil service was founded, for competition and merit-based promotions, which are the foundation of our civil service rules and our city charter's creation of civil service rules. So we do not want to relinquish that. I'm simply relying upon the rules as they're written and the historic application of those rules. Please do not fall prey to saying a $100 a month reduction is a reduction when you compare it to a $2,000 a month reduction. That's a de minimis amount. Also, do not forget, Mr. Doyle has aptly said, suppose no appropriate, comparably salaried position exists. We must eliminate the person. There is no position for them to land upon. We established by our municipal code and by our memorandums of understandings with employee groups the ability to Y-rate employees and solve that problem. We do not have to violate the rules. We do not have to circumvent civil service due process. We literally can move that employee and Y-rate their salary. Now, you still have the right to lay me off. You absolutely have that organizational right. And I am not in any way arguing against that right. I'm simply saying a rule was cited and the financial circumstances of the organization does not allow us to reinterpret and reapply a rule. We must come to you, the Civil Service Commission, and declare we're going to request a rule be changed and you vote on it, or we're going to formally inform you that we're going to reinterpret, not change, but we're going to reapply a rule versus what we have historically done. That's all my contention is. The end does not justify the means. We want to save poor Mr. Wiedeker. Therefore, as a society, we simply cannot allow that to be done. The rules are the rules. The wisdom of our rules is the ability to Y-rate. The wisdom of our rules is you're not painted in the corner and forced to violate the rules to save a good employee. Historically, I stand by my chart, which Mr. Doyle very graciously acknowledged that depicts Exhibit A accurately. I haven't changed a date, a dollar amount. I haven't changed the impact. It's virtually impossible to look at this depiction and not say something has changed in the organization's interpretation and application. The only question is, when did it change? So, why take my word for it? September 1st, 2012 is the bellwether event. That's the date. I ask you to find a transfer in lieu of layoff prior to that date that resulted in a loss in pay greater than $200 for the employee. You glance at your charts, you look at it, and you say, well, there isn't one. We have people losing thousands of dollars a month. $186 is a de minimis amount. It does not free the organization of its responsibility to follow the rules to say, but we offered them a transfer. In essence, that's almost blackmail if you think that you're opening the door to allow discipline in the guise of a layoff or transfer for which there is no appeal. You must have adequate oversight of this process because there is no appeal rights granted. If anything, as the commission, I have to rely upon you to give that benefit of doubt and to say, wow, looks like a duck, walks like a duck, quacks like a duck. Perhaps Mr. Wiedeker is actually showing us something really did change on September the 1st of 2012. So that would be my caveat. First layoff, completely separate from the materials I have submitted to you regarding retaliation, which is current layoff list. Now, no one's under oath. We're not asking anyone any questions. But literally tonight, if you wanted, we could clear up the whole rumor thing and affirm that it either was a rumor or not a rumor tonight, live on the floor, and I would welcome that.
Clear up the rumor as to what?
Was I on a second layoff list to be laid off a second time in 2 years, despite having an exceed standards job performance evaluation, or is that just vicious rumor which the organization should correct to prevent me from experiencing the emotional harm of being subject to that? It's just an opportunity to clarify the rumor that was raised.
Thank you. Did you want to say something?
Yes, Mr. Chair, members of the commission. I don't have no information about this particular thing, but
Okay.
I would say that it is my belief legally that would be confidential, whether it was or not, his name was or was not on any particular list.
I appreciate the input. I think a layoff list is certainly protected and has issues replete with confidentiality of employees, but certainly as it pertains to Mr. Whitaker, if Mr. Whitaker is waiving his right to confidentiality, he can certainly do that. We've had disciplinary proceedings that have been held by this commission in an open setting of employees who were demoted. But I am not here to ask Mr. Whitaker to waive his confidentiality rights as it pertains to his employment status. He seems to have, by inference, done so on the record. I will pose the question, Mr. Doyle. Is there a current list that Mr. Whitaker is on it, and he is checked off for layoff that you know of?
Mr. Chair, we went through a round of layoffs approximately 2 weeks ago. Mr. Whitaker was not among those employees.
Okay. Is there one this evening sitting somewhere that you know of that he's on the list?
There is not.
Okay. That clears that up for me, Mr. Whitaker.
I phrased my question wrongly. It was,
If there ever was?
Was I on the list as of this year and was removed after I appeared before this commission the first time?
Okay, let me...
That's very different.
I understand that question. I don't think I'm going to entertain an answer to that question because I move forward with things. I don't mind looking back if it's going to help me move forward, but I don't think that that's necessary in this instance. Not yet, not now. Perhaps in the future, but not this evening. Any other comments? Because I want to say this. My colleague to my left, Commissioner Warigi, am I saying it right?
Yes.
I'm resistant to say it. Commissioner Warigi, if I heard you correctly, Mr. Warigi, you wanted an opportunity to further revisit some of the definitions of the rules.
That's correct. Personal information.
I will indulge you in that opportunity, and I will join you in that opportunity, and I too will revisit some of those phrases for a better understanding. Is there any objection to continue or defer this matter? Because I don't, this is not an action item for me at this point, Mr. Whitaker. I don't see it.
It's not a note and file item.
It's not a note and file item
Well,
either.
it
Right.
presented it as one, but as far as I'm concerned.
No, it's not a note and file
It's
item.
not a note.
Yeah, no, I have to make some, I believe that
You
this
have to make a
commission,
decision.
this commission has to make some decisions as to, at a minimum, as to the sufficiency of the civil service rules as they exist and as they relate to the issues that you have brought before us, Mr. Whitaker. I believe at a minimum this commission has a duty to make a finding of sufficiency or the lack thereof. If it's there's a lack of sufficiency in terms of expressed intent of these rules, and there's a concern as to any vagueness in these rules or inconsistencies, I will then confer with my chief examiner as to how I would go about, how this commission would go about adopting modifications to those rules or amendments to those rules or clarifications to make it, because I am troubled by where I stopped Commissioner Devine as to that word appropriateness. There's a reason why I stopped Commissioner Devine at that word, because appropriate to me is subject to multiple interpretations, one of which was interpreted by Mr. Doyle. That's an appropriate interpretation. Now, of course, your interpretation is different, and an analysis of the other rules in terms of lateral transfers that don't result in a loss in pay seems to potentially run afoul of an appropriate transfer that may be actually resulting in a loss in pay. So that is something that...
It also runs afoul of the definition in the civil service rules as to what transfer should be. Does the city manager have the authority to transfer to a lower qualifying position? So again, my analysis of it is, and of course you gentlemen will look into that, is that it's not consistent. And it does run afoul of the civil service.
Well, and who knows, we might have words of wisdom from our absent commissioners that will assist us, because after all, the three of us are just people here at 8:30 at night trying to be of service. Mr. Doyle?
Just whatever direction the commission would want to desire, I'm certainly open to that. I just want to caution you about, we can parse what the charter says versus civil service rules. Our interpretation was based upon the rule itself, which I agree with you, Mr. Chair. It's extremely broad. And
it's broad. That's the word I was looking for, yes.
The thing I don't want to lose is the ability to help people retain employment in this organization. And if we are to say, well, we've been misinterpreting this particular provision of the rules, well, I can tell you, about 22, 23 people who would be very disappointed to hear that, because those are the people we have saved from either being laid off or demoted to something or reduced to something far lower than the positions that they're in. And I can tell you, these are some very grateful people in this organization. I know them, I've met them, they've thanked me, they've thanked the city managers, different department heads. The one other point I want to make is Mr. Whitaker brought up Y rating and and saying that this is the perfect avenue for keeping people intact with regard to the need to lay someone off. Keep in mind, the majority of these cases where layoffs are necessary are being done to save money, to deal with a budget deficit gap that we have had in the recent years, and that's real.
That I don't disagree with. I think the Y, to honor the Y-rated system would defeat the purpose of layoffs or transfers to help save the employees, but yet also save the city money. But I am troubled as to the latest wave that Mr. Whitaker alluded to, the restructuring type of activities that are not economically driven and are expressly stated to be not economically driven. Those, at least, I would hope that the spirit of the Y rating would prevail at the end of the day. I would hope. Yes.
Yes, Mr. Chair, members of the Commission.
Sorry.
Just for the Commission's edification in terms of the streamlining, and I've been listening and
Yes.
thinking about the comments of the Commission and drawing the Commission's attention to the provision 23 in the Charter, which gives the authority to the city manager to assign clerks to work in any department, notwithstanding anything in this charter contained. The city manager may, from time to time, in order to facilitate prompt, economical, and efficient dispatch of city business, has, and I'll just summarize, it has broad authority to move various people around the city to fulfill certain roles. And so that's the balance between the authority of the city in order to run efficiently and the preservation or loss of jobs in light of economic circumstances. So while perhaps economic circumstances were not the key reason given for the recent wave of layoffs, certainly it is within the city manager's purview to restructure that in light of the layoffs that occurred before in order to have an efficient service within those departments given the loss of certain positions.
Despite what it may appear from time to time to some who may be viewing the Commission and its actions with some degree of skepticism, I have no doubt that not a single member of this Commission is in the least bit interested in hampering the city manager's ability to run this city efficiently. I, for one, have no such interest, and I don't think there's anyone on this Commission that has any similar interest or unfavorable interest in hampering the administration of the city business by the city manager. I do not. We do not. In terms of these layoffs and the transfers instead of layoffs, we cannot lose sight of the fact that agreements entered into between employees and department heads are, for me as a lawyer, are contractual, whether they are driven by a written contract, an agreement, or whether they are expressed by conduct of the parties. There is a meeting of the minds for this to take place. There must be a meeting of the minds, because if there isn't, now, whether or not the meeting of the minds, Mr. Whitaker will take issue with that it is under duress, under coercion, under blackmail. The words are not mine, and they may not be Mr. Whitaker's. But whatever the case may be, there is, and there must always be, a meeting of the minds before such a transfer takes place for lower pay or no pay, for that matter. Once that occurs, I think the matter is far away from this Commission's purview. If this Commission is to be brought into the picture, because I don't want to say sucked into the picture, Mr. Whitaker, the proper way of bringing the Commission into the picture, or bringing the matter before the Commission, or the picture before the Commission, is at the time that any perceived arm twisting or any perceived coercion, duress, or blackmail or anything of the sort is taking place to secure the agreement of one party, in this case an employee. The employee can certainly, obviously, refuse to be so driven, suffer the consequence of termination and seek reinstatement challenging the termination. I would think that that mechanism, though painful, perhaps must be utilized if this commission is ever to see that which Mr. Whitaker is alleging is taking place is in fact taking place. Otherwise, we can re-agendize this matter and we can make it a not note and file item each and every time. I'm happy to do it as long as I'm chair of this commission. And we can talk about this every session for hours on end. I'm happy to do it. I really am. But I don't know that we're going to get anywhere because this commission is not going to, in my opinion, Mr. Whitaker, appoint you to a position, because that would mean we're going to take the position of a department head and run a department. And I don't think any one of us wants to do that or is inclined to do that. I see my very respectable colleague wants to interject. I want to allow you to interject in case I'm saying something wrong.
Well, no, you never say anything wrong.
Thank you, thank you.
But I just want to say that what you've described, though, in the last comments, in my opinion, is kind of like a catch-22, because
Yes.
as Mr. Whitaker pointed out, the system is set up, or is heading in the direction of being set up, so that the employee does not have an appeal right to the commission to be adjudicated. And what you just described, and I agree with, that really to help someone, the fact has to be occurring at that time. The problem has to be occurring at that time. You know, are they being laid off? Are they being transferred? And at that time, it's something we can get our hands on. But the catch-22 is that because of the system, they don't have the ability to appeal to us. And I think that's what Mr. Whitaker was pointing out, that we're in a situation where we're saying, come back when something happens to you, and the city is saying, well, because of this reorganization or the reinterpretation, you can't come back to the Civil Service Commission. So I think that's something that we need to look at and burrow into to figure out if that in fact is happening. I don't know how to do it. Maybe Mr. Doyle can help us, or Ms. Van Meiden, but my belief is that we need to look at that scenario that Mr. Whitaker pointed out to see if that in fact is a way of demoting or firing employees without going through civil service.
I think the word Mr. Whitaker used is circumventing the civil service position. I remember, I heard everything Mr. Whitaker said. But as I said earlier, Mr. Whitaker, that may be taking place. I just don't have evidence of it before me. And if I don't have evidence of it before me, I do have perhaps smoke before me, but I need to see the house on fire for me to say there's a fire.
But how does that evidence get before us if in fact the civil service rules do not allow an appeal to us to bring those things to our attention? You know, I agree with you. We need to have the evidence, but the way it's set up with the process that Mr. Whitaker is describing, there is no way to get that evidence to us. There is no appeal. And that's what I think we need to look at.
The way things stand now, yes. I'm trying to shy away, and I'm trying to not provide you, Mr. Whitaker, or the city with legal advice. I have plenty to give, but I am not inclined to give any. But there are ways for aggrieved parties to seek redress. Mr. Whitaker ought to consult with an attorney, and I'm sure a competent one would be able to guide Mr. Whitaker if Mr. Whitaker believes he has been wronged to seek redress.
And that's, I agree with you, sir. And I'm appreciative of the time all of you have invested in this. And that's why tonight I literally restricted myself and reined myself in to simply the question on the interpretation of the rule, and that only. So,
and that I will do. We will do that, Mr. Whitaker.
I'm attempting to then unburden you from the other requests, believing that this rule was without a doubt within your purview and the interpretation of that rule. So thank you.
Thank you, Mr. Whitaker. I appreciate you recognizing the sensitive position that this commission is in, because rules we can interpret, rules we can get our arms around, rules are our responsibility to interpret, and if vague, to make it so that it is not vague and that it is sufficiently clear to those who are affected by these rules, and in this case, an employee. That is the reason why I want to re-agendize the matter, to have a full commission discussion as to any modification, if necessary at all. I'm not saying it is or it isn't, as to the rule or the series of rules, the way they interact with one another, so as to alleviate any ambiguity that may exist, if it does exist.
And are we focusing specifically on this transfer in lieu provision, whether to keep it, whether to modify it, or are you asking for something much more broad?
Well, I'm asking for the transfer rules and how they and that one paragraph that Mr. Devine read as to the appropriate. What does that word mean, appropriate? What section was that you read, Mr. Devine? I think it was 2F.
Section 2F.
2F, yes.
Of Rule
Yeah.
11.
Is that different than because I don't have everything laid out in front of me perfectly as some of these things
I
are
think
put up?
in answer to Mr. Doyle's question, that we're going to re-agendize the one item only, which deals whether the interpretation of that 11(2)(f)
Right.
needs to be amended, whether it is consistent with the charter and the rest of the rules, or whether we need to modify it.
Let me
I
just
think that's the only thing we're going to be looking at. Correct me if I'm wrong, Mr. That what you just indicated you would like to.
That is correct. It's just the interpretation of Rule 11(2)(f)
Right.
in the context of the charter and the civil service rules governing transfers.
In the context of civil service rule governing transfers, meaning Article 12, Section 2, Rule 9.
Correct, sir. Rule
Right?
9.
Right.
Because if we agree that it's a transfer instead of a layoff, then it is a transfer and not also a layoff. So,
Yeah, I don't know how we can ever agree it's also a layoff.
Just to be clear, Mr. Whitaker,
Yes, sir.
you would not have a problem in this process if the employee who was going to be laid off was come to and said, hey, would you like to request this transfer to a lower position? And that employee would then voluntarily make a written request for that transfer. That would fall within the current definition. Would you agree with that?
I would have to agree that if the employee is initiating it, that would be within the transfer rules. By my amateur reading, you're saying if the employee were to initiate it,
well, let's say the employee did initiate, but was asked, would you like to make this request? You're going to be laid off.
Right.
Yes, within our current rules, I believe that would be perfectly permissible.
Right. Yeah.
My only concern would be that, again, we're in dangerous waters because of no appeal rights being afforded to the individual. So that's that caveat of, I'm going to do X unless you voluntarily go choose Y because I don't like you. There is no form of appeal for that to this body. So there is, again, no ability to
But
do
you know,
that.
Mr. Whitaker, forgive me for interrupting. Think about it this way. If someone comes to you and says, you are going to be laid off,
Yes.
end of discussion. That would mean your last day of work is today, for example. You're being laid off. Now, just because that person says, but if you don't want to be laid off, we have this other position for you that will make $2,000 less a month or a year or whatever, you're suggesting that, well, they're doing that and now I can't appeal it. It almost begs the question, would we rather, Mr. Doyle or whoever it is that does this unfortunate, task of informing someone they're being laid off, just simply tell people you're being laid off and then have that individual then say, well, Can I get another job instead, maybe less paying or whatever? And then that would be okay.
It would be exactly, now, I'm just an amateur, but that behavior by the organization would be perfectly within the rules as they exist today, because the employee would be presented with a choice and would be voluntarily seeking a lower qualifications transfer.
Right.
And I would interpret that as my amateur opinion to be within the rules.
Mr. Chair, that is, in essence, what's currently being done.
That's what I thought you would say.
Really think about it.
That's what I thought you would say.
Really think about it. The employee can decline the opportunity.
That's what I thought you would say. And that's what I am getting at earlier, Mr. Whitaker. And when I said it, and Mr. Devine said, well, that's a catch-22, what I'm saying is, when someone next, and God forbid it's you, is approached by a department head and is informed, sir or madam or miss, you're being laid off. If that person doesn't want to be laid off or thinks that they're being laid off as a retaliatory measure, they're being set up so they can say, well, I know that there's this lower qualification transfer I can ask for. That person is going to have a vested interest in this battle, if you will, and take that layoff and then seek redress as a retaliatory layoff or a firing disguised as a layoff.
And wrongful termination.
Thank you, you said it.
I believe you're exactly correct. And I would agree with what you've just said 100%. The only dilemma is, in my experience, and I suspect in others, they were not afforded the option. They simply received a letter that informed them, you, effective whenever, are transferred into a lower position. And by my reading, it's a demotion, not a transfer, with no discussion, no options, a letter received in the mail. So,
Mr. Chair,
did it say in lieu of a layoff?
If I could interrupt.
One second. Did it say in lieu of a layoff?
yes, sir.
Okay, that's sufficient for my purposes. Yes.
If what we're saying in order to resolve this is to modify that letter to say it is proposed, number one, you're being laid off, but however, it is proposed that you be placed in this position as an alternative to going to this position. If we can resolve this by modifying the layoff letter, then
I would
may not need to bring this back.
I would do this even. I would even do one more. I would propose that you send the layoff letter, and send a layoff letter with no proposals, and have the employees inquire and see what options they have in lieu of a layoff.
We can do that too.
Well, I mean, there's a benefit to knowing that there's an option, so there could be language that, if you would like to request.
I will state, members of the commission, that layoff letters do
I've never
contain
seen
the
one.
information,
Yeah.
and they are given the right to contact the city manager's office if they have concerns or ideas or thoughts about the fairness of the layoff and whether or not there are alternatives. So that's already built into the process. But as I said in my presentation, I mean, we try to be proactive. If we can see or foresee a creative means of providing this individual with a better alternative than the unemployment line, those are the types of things we try to do.
Which is very commendable.
That is different than.
Hope so.
Yes.
That still does not address.
This I was just saying.
Yeah.
That is different than the rule interpretation
Exactly.
and the clarification. The rest, in terms of how the letter ought to be rephrased and whatnot, yes, but that doesn't eliminate us bringing it back. I do want to bring it back because I want to have closure, and I want everyone to go away happy and satisfied and understanding everything. And we will make that happen. We will make that happen. Thank you very much for being here, Mr. Whitaker.
Thank you.
Next item. Civil Service Commission staff comments.
There better not be any. Any staff comments?
I have an order, presentation?
My comment is, thank you all for being here so late. It's 9 o'clock. Yes.
Mr. Chair, I would ask that we have your permission to cancel our next meeting. I'm down 2 members of staff. Ms. Abramian will be on vacation for a few weeks, and she
Is that on the 15th?
22nd of October.
22nd, oh, 22nd, yes. So what would be our next meeting then? It would
be the
November...
the second week, second Wednesday of November.
Second Wednesday, yeah.
Yes.
Yes.
What date is that? November what?
20,
Let me look here.
5th. It would be 5th.
No, it would not be the 5th.
It would not?
It would be the 12th.
Oh, it's the second.
The
Yes,
second
yes, yes,
and
yes,
the
yes.
fourth.
Yes, I apologize. I'm confusing it with another body. I attend meetings on the other Wednesdays when I'm not here. November 12th is our next meeting. That is fine. Okay, that being the only other comment, we are adjourned.
Second.
Thank you. Do I need to sign it?